Okay, I'm calling this Planning Commission meeting to order on Thursday, June 20th, 2024. First item of business is the determination of a quorum. We have 4 commissioners present in the well, and we have another commissioner present online. So we do have a quorum. The next item is the adoption of tonight's agenda. Do I have a motion to adopt the agenda?
I motion to adopt the agenda.
And
I
second?
second that.
Great. All in favor?
Aye.
All opposed?
Aye.
Motion passes. All right, this next portion of the meeting is visitor communication. And I just want to remind everyone, this is a time provided for individuals wishing to address the Planning Commission regarding issues not already on the agenda. So if you are here for short-term rentals, this is the time for you to stay seated and listen. If you're here for something else and would like to speak, please feel free to come forward. Not seeing anyone here physically present. Is there anyone on the WebEx or the Zoom who wants to speak?
There anyone over Zoom who would like to provide testimony that is not on the text amendment subject on the agenda? If you do, please raise your hand. There's a button on Zoom that you could click. It's the raise hand button. If I see any hands be raised, I'll call on you. Seeing none, we can move on.
Great. Next item is approval of minutes. Do I want to approve these one at a time? That's one thing I should have. Okay. We can approve. Do I have a motion to approve the minutes for March 7th and March 21st?
I'll make that motion.
And do I have a second?
I'll second.
All in favor?
Aye.
Aye. Opposed? Motion passes. All right. Now we turn to the public hearing for the short-term rental development code text amendments, city file number 2A24-02. This is the time set for that public hearing. The applicant in this case is the City of Sisters. This meeting is now called to order. Bear with me, I got to read through this script and it's my first time doing it. So the conduct of the hearing will be as follows. To start with, staff will make a presentation and commissioners will ask questions to staff regarding that presentation. After that presentation, we'll enter additional correspondence that was received into the record. After that, we will open the public hearing for testimony in the following order. First, we'll have testimony in support of the proposal. Next, we'll have testimony in opposition to the proposal. And then finally, we'll have neutral testimony. After that, questions of staff by the Planning Commission will take place. At that point, we will close the public testimony portion of the hearing and there will be no further testimony. And discussion and decision by the Planning Commission will take place at that point, and we'll decide whether to deliberate further, keep the record open, those types of things. With regard to testimony, please note that your testimony will be accepted in person and remotely via Zoom. If you would like to speak, please provide your testimony after you are called. If you do not wish to provide testimony and we call you, please say no testimony, and that's fine after you're called. Any questions should be directed to me as the vice chair, acting chair. When you testify, please state your name and address for the record, and please speak clearly and loudly to ensure that your testimony is heard, as this hearing is being recorded and we do have one commissioner listening via Zoom. Callers will be muted after their testimony concludes. I may limit testimony to 3 minutes per person. I would encourage those wishing to speak to keep testimony concise and relevant to the issue before us this evening. It is encouraged to simply agree with a point made by another person instead of remaking the point. For our deliberations, the applicable substantive criteria are listed in the staff report. These are the criteria that the Planning Commission, all of us, must use in making this decision. All testimony and evidence must be directed towards these criteria or other criteria in the comprehensive plan or other land use regulations that the person testifying believes apply to the decision, testimony that is not directed towards applicable or potentially applicable approval criteria, even if a strong point is ultimately not relevant. A failure to raise an issue with sufficient specificity to afford the Planning Commission and the parties an opportunity to respond to the issue precludes an appeal to the Land Use Board of Appeals based on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the Planning Commission to respond to the issue precludes an action for damages in circuit court. Before the conclusion of the initial evidentiary hearing, any participant may ask the Planning Commission to provide further opportunity to present additional relevant evidence or testimony that is within the scope of the hearing. At this time, I will ask if any commissioner has any conflicts of interest. If so, please disclose the nature of the conflict and whether the member believes the conflict would preclude the member from objectively participating in these proceedings. I will start. Why don't I start with Commissioner Retzman on Zoom?
I have no conflicts and I can participate.
Great, thank you. And Commissioner Reese?
I have no conflicts and I plan on participating.
Commissioner McDougall?
I have no conflicts and plan on participating.
And Commissioner Blumenkraut?
I have no conflicts and I plan on participating.
And I have no conflicts as well. I plan on participating. Is there any member of the audience who wishes to challenge the ability of any commissioner to hear this matter? We need to unmute people on Zoom to check.
I'll check to see if anyone over Zoom has their hands raised. I don't see
Not
any.
seeing it. All right. So at this point, we'll turn to staff and let them present their report.
Thank you, Vice Chair Dickman. Good evening, Matthew Martin, Principal Planner, City of Sisters Community Development Department, joined here by Scott Woodford, Sisters Community Development Director. As introduced, what we have before you are some text amendments to Sisters Development Code Section 2.15.2700. Those are the special provisions applicable to short-term rentals within the city limits of Sisters. File number TA 2402. My intent of my oral and presentation here tonight is to supplement the staff report that was provided to the commission in advance of tonight's proceeding, which provides the detailed analysis of the specifics of the proposal and compliance with the applicable review criteria, elements of the Sisters Comprehensive Plan, and applicable Oregon State land use goals. And purpose here is to provide you some background on what brings us here today and the purpose of the amendments and some background on our process to date, and then detailed description of the proposed amendments, and then an overview of what your options are moving forward. I'm happy to field any questions throughout or at the conclusion of the presentation. What got us started was part of the City Council's goals for this fiscal year that's coming to an end here in June. And that was specifically to evaluate short-term rental code language to mitigate adverse impacts on the community. In particular, the council expressed an interest in understanding what those impacts may be on availability of housing units for long-term rental or long-term occupancy, as well as any nuisances created by short-term rentals operating within the community. Just pausing there, I think it's a good opportunity to highlight what a short-term rental is, just for the good of the order. Short-term rentals are specifically defined in the Sisters Development Code, and in summary, it's a dwelling unit that is rented for a period of time less than 30 days, consecutive days. Anything over 30 days would be considered long-term occupancy and fall under a separate set of standards as it relates to that use of a dwelling unit. A dwelling unit comes in a variety of forms, from a standalone detached single-family dwelling to townhomes that have a common wall, to duplexes, triplex, fourplex, and multifamily developments and accessory dwelling units. So thinking about it broadly and what a dwelling unit is in its use and characteristics. Acknowledging that this definition also applies to those short-term rentals or what were previously known as vacation rentals that were established prior to the current code that was adopted in 2018. And noting that it does not include bed and breakfast, hotels, or motels. Those are different use types, subject to different use allowances and specific use criteria. I want to acknowledge the work that both the commission and city council have done to date, as well as the public involvement that we've had throughout the process, beginning last fall with a series of workshops that bounced back and forth between the city council and planning commission, where it provided a variety of resources and information to help refine the scope of the project that's before you today. So it began with the series of workshops that included an overview of our current program, what those regulations are, and what the impacts are from revenue sources, complaints or non-compliance issues, and permitting stats. Throughout the process, we also collected data from our partner agency, the Deschutes County Sheriff's Office, to identify what calls they've received that are specific to short-term rental properties, maybe not the rental of that property, but specifically those properties. And also circulated a survey to all short-term rental operators and owners to solicit feedback on how it's going for them, what their characteristics are, but also what their experiences are. I had a great response rate of nearly 50% to that survey, which was just, I appreciate, thank, and commend the owners and operators for participating and give us that valuable feedback. And in addition, we analyzed a variety of potential code amendments that could be, were considered to be made to change the program and further refine it since it was adopted and implemented in 2018. Throughout the workshops, we concluded in March with City Council, where they provided direction to staff to pursue the package of amendments that's before you today. Now it gave us a general scope of what those amendments would be, but since then, we staff have drafted those amendments and worked in concert with legal counsel to help refine and wordsmith and dial in, so to speak, the text of the amendments. So that direction that City Council provided to staff to pursue were to, one, prohibit short-term rentals in the urban growth boundary expansion or city limit annexation areas, with the carve out for unless the city council at that time for a particular reason would like to allow short-term rentals in an annexation area. Also to expand the concentration limits from the current 250 feet to 500 feet. And then apply concentration limits to condominiums, which are currently exempt from the concentration limit. And then also apply it to residential only developments within the downtown commercial district. And that's specific to some distinct areas in the northern portion of the downtown commercial district that are identified within our development code. The figures 1 and 2 that are on the screen are those maps and figures that were adopted into the Sisters Development Code. So it's in general proximity to Adams Avenue in some areas that otherwise, within the downtown commercial district, residential only developments, subdivisions, multifamily are not allowed in the downtown commercial district. But as part of our recent efficiency measures and efforts to get more dwelling units within the community, these areas were provided a carve out, special use standards that allow for residential only developments. But wanted to identify that those are for residential use to provide dwelling units within the community, and an interest in applying the concentration limit there as if it as it is applied to other residential districts. So now to dive into the specific amendments. What's on the screen, and the subsequent slides is the text amendments as proposed. And what's included is any additional text is that added and identified with underline. Any deleted text or replaced text is shown through strike through. So the first being that prohibition that we spoke of in annexation areas. Again, this is to identify that a prohibition applies for any areas that are annexed after the adoption of this ordinance, unless the city council at the time specifically permits short-term rentals as part of an annexation agreement. Next being, and perhaps the most prominent, is the application of the concentration limits. Now you see a lot of additional text, and you may find that it's repeated almost verbatim in the two separate sections. This was under the guidance of our legal counsel to be abundantly clear into what areas that it's applied and to where the short-term rental is located, and then conversely where it's applied around that short-term rental. So again, it's where the short-term rentals are allowed in the residential district, the multifamily residential district, the Sun Ranch residential district, the urban area reserve, and the North Sisters business park zones or districts. Those are all zones where short-term rentals are allowed today, and also where the concentration limit is applied today. The additional text and the detail are those residential only developments in the areas identified in figures 1 or 2 of the table 2.4.1 of the downtown commercial district. Do want to be clear that this is not intended and does not apply to multi-use buildings, where a situation where you have commercial on a ground floor or at the street side, and you have a residential unit on an upper floor or behind that commercial. The council was clear that was a distinct difference in use category and more of a commercial setting, rather than these areas where you will have just a traditional residential use and residential only environment. And noting in the middle here that concentration limit would be increased from 250 feet to 500 feet. The next being the application of the concentration limit to condominiums. As noted in 3 and the strike through, 3 currently provides an exemption for condominiums from the concentration limit, meaning that condominiums can be within 250 feet of each other, could be part of the same complex. As proposed, the limitation would be that condominiums would be subject to that concentration limit of 500
I
feet.
have a question for him. So applying this limit to condominiums, so let's say that somebody bought a condo in 2019.
Can you
And
please speak up?
they bought a condo in 2019 and they had a short-term rental since 2019. When this is applied, would they be grandfathered in unless there's a new owner? Or would they have to reapply and not be able to?
Yeah, it's a great question. None of these changes would apply to currently approved and operating, appropriately licensed and operating short-term rentals.
So as long as the current owner keeps the unit, they're grandfathered in.
Correct. Yeah, so you would be able to continue that operation. There are different timeframes and types of short-term rentals of which transferability is limited or otherwise as allowed on those older units. We can highlight that a bit later. But to answer your question, if you're operating a lawfully established short-term rental today, and if these amendments are adopted, you could continue that operation under your current ownership.
Okay, thanks.
And we'll revisit questions after, I think, the staff report and then correspondence.
Yeah.
He said he wasn't.
Oh, okay, sorry.
I'm happy to field them, but
Okay.
at your discretion, Vice Chair.
No, go ahead. We just don't want to trip you up in the
No.
middle.
And then noting what's currently 4 would be 3, the increase of the concentration limit from the 250 to 500 feet. And so speaking of transferability, currently in the code, any short-term rentals that were applied for after December 28th, 2018 are not transferable to new owners. Those land uses specifically are associated with the current owner at the time of the application. So what that means is for those that were applied for after that 2018 date, that once it takes ownership from a new future owner, that does not go with the land. That future owner would need to apply for a new short-term rental approval. That requirement does not change with these amendments. But what needs to be clear and what's been added at the advice of legal counsel is to note that that future owner and that new and future short-term rental application is subject to the regulations at the time of that application. I want to highlight that because the implications of these changes could be significant to some or many short-term rental operators today. So those that, for example, if you're operating at 251 feet from another short-term rental today, and the concentration limit is expanded to 500 feet, you sell that property, then that subsequent new owner would not be eligible for a short-term rental because of the expansion of the concentration limit or the application of the concentration limit to condominiums. So the addition of this text is to emphasize that that application of the standards at that time of the new application. I think I'll stay here for a moment to build on the prior answer that for those short-term rentals lawfully established prior to the end of 2018, they have different transferability standards that are built into the development code as well as the short-term rental operator license criteria. In short, those approved prior to 2018 can be transferred to future owners and do run with the land. That's an important distinction from those that were prior approved versus or pre-existing and those that were applied for and approved after 2018.
You know what kind of percentage was prior to 2018 as opposed to after?
I think we are near, got that number from.
Can you repeat that question? I could not hear you.
Talking right into the microphone. I was just asking what percentage was prior to 2018
Oh, thank you.
so that we could get an idea.
Yeah, so from my earlier stats from our original workshops, which these numbers are fluid because we've had additional short-term rental applications, but prior to the December 2018, there were 77 short-term rentals operating. And so we are now at approximately 120 total short-term rentals. So doing quick math, about 60%, over half were pre-existing short-term rentals.
Thank you.
Next being those non-conforming or prior existing short-term rentals. This is to provide some clarity and of the changes that and the applicability of these changes and that we're making now. And with making any of these changes now, all existing short-term rentals become some level of non-conforming because the code changed after they were approved. So this is just to acknowledge the instead of the date being the 2013, that was the prior distinguishing point. Now it would be the adoption of these new standards, which would be applicable to those pre-existing. And then for further clarity, subsection D acknowledges that those approved after 2018 are subject to the transfer restrictions that we previously discussed. And that's the extent of my overview of the amendments. I'll speak to next steps. As you're aware, a commission has a number of opportunities or options at the conclusion of testimony. That could be to continue the public hearing in its entirety, or close the public hearing for oral comment, leave a written record open, or close the hearing in its entirety, set a date certain in the future for deliberations, or do it all tonight. Close the public hearing and complete deliberations. And for the decision or recommendation, options are approve as drafted, approve portions as drafted, approve with some amendment, or deny in its entirety as drafted. So I'm happy to answer any questions you may have now. Thank you.
The script tells me to ask each commissioner whether they have any questions for staff, but I feel like it might make more sense just let people have a free for all. If you have questions.
Can you speak into your microphone, please? I'm sorry.
If you do have a question for staff at this point, commissioners, feel free to just interject. I'm not going to call on people.
I have a question
Go ahead.
on section F, limit on permit transfers. I've read it several times and I get confused. So I have I'll just put it again, a question for you, Matt. If let's say my brother owns a short-term rental and passes away and I inherit it, does the permit come with me?
Yeah, so there's specific language for that scenario. So if the ownership remains within the family, then it's still the same ownership.
Gotcha.
So there's not a transfer involved, but it's still the same.
Even if
ownership.
let's say my mother-in-law had it and the name is different. My name is different than her name. It still stays in the family. Is that correct?
Now you're throwing him for a loop.
So
Like a bar exam question.
Yeah.
You want the specific section of the code read in terms of what exactly it says in terms of what
No,
transferability
No,
is?
I'm just trying to understand it. That's all.
There's some limited opportunities for where transfer can occur within family to a trust. Upon the death of an owner, change in ownership where the title is held in survivorship with a spouse or domestic partner. Upon the death of an owner, transfer to a trust which benefits only the decedent's spouse, children, or registered domestic partner for the lifetime of the spouse, children, or registered domestic partner. C, the transfer of ownership of the real property to or between members of a limited liability company. And D, transfer to a trustee, a corporation, a partnership, limited liability partnership, or similar entity if at least one owner is living at the time of transfer and retains at least 25% of the interest. So
Yeah.
those are the circumstances
I
under
read-
now.
I've read all that, but it's kind of confusing to me. So I just wanted to know if that was the case. It can be my grandfather or my grandmother with a different last name from me because it's still in the family.
It's pretty specific in terms of what members of the family can be eligible.
Yeah, I'm reading it as it would not, that would be excluded. That's how I read it.
yeah, I think I overspoke. So excuse me when you spoke of the death of a sibling. That as Scott noted, I think we're beyond that relationship.
That's interesting.
So to me, reading through all of this, if somebody bought, let's say, a house with a short-term rental, they knew that after 2018, they knew that it wasn't going to be transferable. But if somebody bought a condo, they may have been figuring that, well, I can have it as a short-term rental, and then since there's no rules regarding condominiums are excluded, I'll be able to sell it and that person will be able to have a short-term rental. But that's not the case anymore. So those, I guess the only people that would be caught unawares would be the condominium owners.
I think I'd build on that. It'd be those also that were within beyond 250 feet and 500 feet from a short-term rental.
Right.
So I think that would also be that same group. So both condominiums as well as those beyond the 250 feet, between 250 and 500, that would not have perhaps been thinking about a potential change to the code. But that decision would have explicitly identified the limit on transfer.
Okay.
Any other commissioner questions for staff?
I do. We talked briefly, and maybe you guys remember, when we were discussing this before on one of our workshops, we were talking about the scenario of the requirement to keep a short-term rental, and correct me if I'm wrong, is you have to rent it out once a year. And the conversation we had was, well, that's kind of interesting, that you have to keep your permit, you have to rent it out once a year. And then what ensued was our conversation was, well, I could, the reasoning would be, somebody could have this reasoning. I'm going to apply for one because I don't want any short-term rentals around me. And I'll just rent it to my brother-in-law once a year, and I will keep short-term rentals 500 feet from me. And it's not in this.
Yeah, it didn't get changed, I guess.
Well, no, I was talking to Matt about it. He said the city council wasn't interested in changing that specifics to add, you had to rent it for 4 times a year or 12 times a year. And so I just wanted to.
Just maybe to clarify for staff, then we could, if we wanted, propose adding that language, if not, foreshadowing any of our deliberations, but like we could propose an addition like that as part of our decisions.
So I think it certainly could be discussed and brought forward to the city council. I know that, what's before you now is a package of amendments. So we don't want to get too far away from what was the direction of the city council. But certainly if that's something that is still of interest to the planning commission, we can acknowledge that when we bring any recommendation forward to the city council.
Yes, so we can talk about it in our deliberation.
Any other questions of staff? Commissioner Retzman, anything from you?
No questions.
All right, so barring any last second questions from commissioners to staff, we'll now invite members of the audience to provide testimony. When called, please come forward and state your name and address for the record before proceeding with your testimony. When your name or number is called, please indicate whether or not you will be providing testimony. For those attending via Zoom, we will conduct a roll call to see who wants to provide testimony.
Vice Chair, excuse me.
Oh, sorry.
Just another procedural element to identify any additional correspondence that have been submitted in the record.
Okay, yeah. Have we received any correspondence on this matter other than those items included in the agenda materials?
Yeah, I just want to acknowledge that since the agenda was prepared and distributed, that a number of comments have been received. So I wanted to read and I've emailed those to the commissioners as well as provided printed copies to those in attendance, but I wanted to read those into the record by reference, if I may. So those being a June 14th email from Mr. Grammer, a June 14th email from Mr. Lindley, a June 14th email from the McGriffs, June 17th email from Campbell, a June 18 email from Radloff, June 19 email from Ryder, June 19 email from Stevens, a June 20 email from Grabsky, a June 20 email from Gray, a June 20 email from Harker, a June 20 email from Reber, and lastly, a June 20 email from Reigner. And that would be it. Thank you.
All right, thank you, staff. So with the questions of staff finished from commissioners, we'll go to public testimony. I'll start by calling the names here, and this one I think I can pronounce, but in the future, I apologize in advance if I mispronounce your names. Paul Bennett, would you like to speak?
Hi, my name is Paul Bennett. I live at 159 North Rope Street, just down the street here. We've had a short-term rental for about 10 years now. And we've had people from all around the world stay with us, as far away as Sri Lanka and Bangladesh. All people from all around the United States and Europe. And it's been a great way to bring the world to us. So we've really enjoyed 99% of the people who have stayed with us. After our son moved out of our house, after he went off for college, and now he lives in Europe, we had an empty room in our house, and that's just the nature of houses. People come and go. People get divorced and die, and kids grow up and leave and remarry, and all these things happen. So a house is a dynamic place, and it's very common to have an empty room in your house. Now, another thing we have done with that empty room, on 5 different occasions, we've had relatives or friends stay with us for months at a time because they were in a transition time in their life. In 4 of those cases, it was a divorce. They just were in they needed a place to stay for a couple of months. So they stayed with us. A woman couldn't get back to her country because her visa didn't allow her to do that until during the COVID period. And and I'm sure all of you have relatives stay with you at times, and that's not, it's not a short-term rental situation. You're just trying to help out a friend. We've also had bicyclists come through that stay with us, and they're always interesting people. And we've had musicians, we've had artists. I know through our church, they have a way to, if you want to be part of allowing a room in your house for someone to stay who is involved with the church. There are all kinds of organizations in every city where people, they're just, they want to help out if they have an extra room in their house. So, whether you put these restrictions or not on the STRs, there are going to be people coming and going in your neighborhood you don't know, because everybody is in this kind of a situation, some more than others. But so I think really often the problem comes down to the HOAs, that things aren't enforced, or that the homeowners themselves are not enforcing or clearly defining their rules and regulations about how this house and home and room should be used. And, I feel badly that my neighbors across the street won't, young couple, they won't be able to rent out a room because we're within that 250-foot or 500-foot radius right now. But they could still use this room for all these other things I've mentioned. But the advantage of an STR working through Airbnb is that you feel safe with these people because they've gone through certain steps to get to this point, and you've communicated with them. And often when they arrive, I feel like I already know you, like you're a lost long relative. And it's much different from, say, if you have an empty room and you just want someone in there and you post an ad on a bulletin board somewhere, you're just not sure. I would be uncomfortable with that. But one of the advantages there of the Airbnb is that is a safety factor. It's a win for the city in terms of money. It's a win for the homeowners because it helps with their expenses. We make just enough to pay our property taxes. And so it's not a big source of income for us, but as I say, it's a great way to see the world, but or to meet the world. So I think a lot of the issues are really with the HOAs themselves, with the homeowners themselves, just being clear about what's expected of the people that are going to be renting in their houses. So I'm here to learn and find out really what the issues is, but I hate to hamper people that are just, often in a situation where they're just trying to get by and they need a little extra cash. And another idea I had, what about if somebody wanted to rent a space in their house for as a cold weather shelter, and just said, we got this room available, but how do we let people know, and they could have it for free. But during those evenings when someone's out there camping and how can we make that happen? If we have these restrictions, that couldn't happen, but it could happen, though you could make that work. So we could be solving a problem here with houselessness too. So I know this is a complicated issue, and I know you've given a lot of thought to it. But as is my example here, you can see all the different ways that we use empty rooms, and everybody uses an empty room in their house. A lot of it is just how comfortable you are with having someone in your house that you haven't yet met, or having someone in your neighborhood that you've not seen before, but they just could be the brother of your neighbor, and you don't know who that person is.
Thank you.
So anyway, that's a little of my background there. Thank you.
All right, next on my list here is Charlie Stevens. Would you like to speak?
I'm Charlie Stevens, 1086 West Collier Glacier Drive here in Sisters. I'm here speaking on behalf of Better Living in Sisters, a few members of whom are here with me tonight. We've reviewed the public record for these discussions that goes back about 5 years. And we kind of came to the conclusion that what's being proposed is a pretty good representation of an outcome that would come out of those conversations. So it seems logical to us that the proposals arrived where they did. As a group, we think they'll help the city in its efforts to maintain housing affordability going forward. We recognize it doesn't have too much of an impact on what already exists, but we strongly support the text amendments as they're proposed right now. I don't take issue myself. I can't speak for Bliss on this issue at the moment, but I don't have too much objection to what Mr. Bennett was saying. There might be some reason for further conversation about specific situations, and we might support that or not going forward. But we would hope that the Planning Commission will forward this to the City Council for approval. Thank you.
Thank you. Next on my list is Jeremy Dubose.
Yeah, thank you. Jeremy DeBose, 247 North Locust. We bought that property in 2020. My wife and I made significant investments to convert it to the short-term rental and operate those permits. And what we found is we have been attracting people to Sisters for a long time. And our users spend a lot of money in our local businesses. They spend a lot of money at restaurants. They spend more money than some of our other long-term rentals do. So the support for the overall community and the impact to the overall community from tourism, from people visiting is pretty significant. And when we read the report, it looked like about 4% of the current inventory in Sisters was under a short-term rental permit. And the concern is that we're kind of putting the cart before the horse without addressing the kind of the housing affordability and the housing crisis first before making these comments to short-term rentals. It seems a little preemptive. And I know we want to keep the community here. We want to keep those housing developments strong, but without I know it's been talked about, but it hasn't been adequately addressed, the future housing growth, where it's going to be the kind of the trajectory of Sisters. We in turn have also been looking at adding on another unit to our property. And our concern is that if we were to apply for that in our existing zone, would the rest of the property, would the rest of the short-term rental permits be impacted? Would those go away because we purchased the property in 2020? So there's a lot of questions. I think the text amendment, I think it could be adopted with further amendments and further clarifications, but those are a few of the questions we have. And the other concern we had was future investment in Sisters. Short-term rental does allow people to live in Central Oregon and offset the cost of living and operating in these properties. We have two folks in Redmond that we rent to as well they're in Arizona for 3 months a year. They're here for 9 months a year. They're able to offset, we're able to offset the cost of that property with their income with the short-term rental. So I would just suggest some further amendments to the proposals for the future, but also kind of a broader addressing of the housing issues in Central Oregon. Thanks.
Thank you. Next up, I have Tim Hicks.
Hi, thank you. Name is Tim Hicks and the address is 191 East Telfair Court. Just wanted to kind of share how I anticipate this potentially impacting us in our story with short-term rentals. My wife and I thought that investing in short-term rental would be a good long-term opportunity for us. And so we specifically picked out a lot in the downtown zone because the zoning at that time allowed for it. And we built a fourplex. So we have 4 short-term rental permits for the fourplex. And it's been a great experience for us. I think we offer visitors to Sisters a really good value. Our average nightly rate is like $145 a night. Compare that to most of the hotels in the area, it's significantly more. And our guests are always asking for cafe and restaurant and shopping recommendations. They're visiting downtown on foot, reducing traffic, and they're enjoying their stay. And so we're kind of like the others have said, we're really promoting Sisters as a destination and providing an alternative to a traditional hotel. And we also employ 2 part-time cleaners year round who live in Sisters, plus a third during the summer. So we're able to offer some employment opportunities to our local neighbors. So I believe that we're positively contributing to Sisters because we have a short-term rental. I thank you so much for grandfathering in the existing permits because we wouldn't be able to pay our mortgage if we had to convert to a long-term rental. This was designed for short-term. But if at some point down the road we decide to sell, because we're in the downtown zone in a residential building, if I understand the text correctly, at most we would retain 1 permit potentially if there wasn't another permit within 500 feet. And so the valuation of our building would be less than it would otherwise as a multifamily building. It would be traditionally based off of the income that the property produces. Because we work hard managing the guests and cleaning the short-term rental, we would then lose the opportunity to have it valued at that, and it would be valued at a lower long-term rate. So we would lose some valuation there. So my ask is to consider a way to kind of grandfather in existing uses, particularly in the downtown area. And then I also just wanted to point out the other benefit in the residential areas in particular is that people are able to achieve home ownership when they know that they could potentially offset some of the cost of home ownership through short-term rentals. Thank you.
Thank you. Next up, I have John Chase.
Good evening. My name is John Chase. I live at 754 South Oak Street. And I strongly oppose all short-term rentals. Most of the cities in Oregon that have had an excess of tourism have put moratoriums on them. I don't think that this text amendment goes far enough, but I would support it in its current form if it's limiting future short-term rentals. The previous couple of people you've heard from have very different scenarios. Mr. Bennett has what I would consider a very traditional type of Airbnb, which is what that whole business concept was designed for when it started. That seems pretty acceptable to me. Somebody that lives on that property and wants to rent out an ADU or a bedroom or something seems pretty acceptable. really not much of a disturbance to the neighborhood. But on the other hand, you have people investing and investment groups grabbing properties and setting them aside only for short-term rentals, which is a business in mostly residential neighborhoods, and it shouldn't be allowed. It's also a tax advantaged business with the federal income tax. So I strongly oppose all the short-term rentals. I think the city should put a moratorium on it as a whole. Maybe as there's some differentiation between how some are operated and maybe a better definition of that would be beneficial moving forward. I also think that on the amendment to decimal 15 decimal 27D2, it leaves an exception there with the potentially annexed land. And it says, unless STRs are specifically permitted in an annexation agreement approved by the city council, I think that should be struck. So that's really leaving an open door to some future city council to open that up again, when it looks to me like this text amendment is prohibiting any STRs in the future annexed land. And everyone I know that lives in my neighborhood doesn't want them. We don't want them around. I also know of one that operates right down the street from me, of which I've sent to the code enforcement of the city, and it's still operating. It's 575 South Oak Street. Thank you.
Thank you. Deb Meyer is next.
Hello, I'm Deborah Meyer and I live at 69707 Holmes Road, Sisters. And my husband and I, we have a couple of rental houses in town. But when we purchased our licenses, it was in May of 2018. So I believe we're grandfathered in under a bit of a different criteria than this now existing group. And I appreciate the clarification earlier where I'm now able to understand that if I did want to transfer those licensing rights, if we sold the property, that it would withstand. And then there was a comment made by the council earlier saying, well, maybe there's the gentleman who's purchasing the short-term rental just to avoid having one in the neighborhood and potentially looking at increasing the number of minimum days that you have to have the property rented out under your short-term lease. I would hope that wouldn't affect the group being grandfathered in, and I can't really comment on the current group, but what I would like to say is that this flexibility of just having to rent the place out for just one day or a few days of the year has also allowed us to place long-term renters into the properties in the interim durations. So it's like it's benefited people who want to live in the community and are able to stay there, and versus us, if we want to rent it out to visitors or other people just for a short time, then that's another option, as long as we're falling within the time requirements. And I think the subject of a short-term rental or long-term rentals versus the affordability of being able to have affordable houses in town are like two distinct entities in looking at properties. But what I would agree with is that having short-term rentals could impact the availability of people looking for long-term residences. That's all I have to say. Thank you.
Thank you. Next, I believe Vincent Gallagher.
My name is Vincent Gallagher. My address is 1139 Luridell Avenue South in Salem. I'm different than apparently all these folks are locals and voters or whatever. I've lived in my house in Salem for 25 years. My brother is also in attendance here, is a Bend resident in the same house for like 40 years. Our family owns a house across the street from Village Green. But we've been in the family since the 50s. My mother sat on this committee, fought with McDonald's. And she and my sister have lived in that house over the last 45 years and had no purpose in renting the house. In our case, they have both passed now, so the house is there. We use it. But I don't intend to sell my house in Salem in order to live in it. Neither does he. We would like to be able to rent it. We weren't aware of the 2018 program. So we missed that. I understand that. So I think we're out of luck in a sense because we are contiguous to several, which I assume are grandfathered STRs. So I have questions about the structure that would be for the staff, but I think it's more, that would maybe be through you. So I'm just curious why the change from 250 to 500? I haven't heard any justification for it. Not that I'm demanding justification, but why the change? When I think of 500 feet, that's basically, if I have a home with a rental license, it protects me for about 1,000 feet or about a quarter of a mile around. Sounds to me like roughly. So I'm curious if there's been an analysis of if you'd extend these STRs to 500 feet, and it may be a prudent policy, but are there any valid spaces left in the city that'll be eligible for STRs for new licenses? I mean, are there big gaps where there are open spaces where nobody has a license and someone could utilize an STR? In my case, the one neighbor never rents the property. He may do the one, he may do 2 or 3. We aren't here every day. The other one is on our property line. They rent it frequently. They're owners from out of town, which is fine. And we're totally unconscious of them. One of the gentlemen is totally opposed to STRs and talked about communities that have big issues. I'm not aware of them. I don't live here. I understand that's an issue and could easily be. But I've had drunk neighbors that were more trouble than college kids on a weekend, and I can't boot my neighbors out. And I've always been supportive of zoning, but this just seems like a taking of people's assets, the value of their property. You're eliminating it for the benefit of who? So my last question would be, how many complaints have you had about this that would require an expansion of the problem of the exclusion zone or whatever you'd like to call it? I don't know if we'll be able to maintain the property. Actually, we don't maintain it very well. You might rather have McDonald's houses built there. It's a little shabby at this time. But with property taxes and all, and not living there and not renting it at all, which we never have and don't know that we would, I'm just concerned that this is not, who's it benefiting? How much problem are we solving by taking away rights from everybody in town? That is a renter or an owner, and not everybody obviously, but I think that's about all I had. Thank you.
Thank you. Okay, I don't have any more forms, so I guess I will now hear from those attending via Zoom who wish to testify.
Let me pull that up. Great. I see some hands raised. Good job, guys. Okay, I'm gonna first call on Newt.
Hi, my name is Newt Radloff. I live at 1115 Southwest Sylvia Street in Corvallis, Oregon. I have similar concerns as to what the city of Sisters is trying to address. I mean, I know it's housing affordability, and there was mention of nuisance created by short-term rentals. I'm just very skeptical that this proposed rule change would have addressed housing affordability. You have 77 short-term rentals that are established prior to 2018 or in 2018, and the STR permit would transfer when that property is sold. So presumably those would never enter the long-term housing stock because they will be short-term rentals indefinitely. And you have 43 where you would be at risk of losing your short-term rental eligibility if you sell the house, and that seems like a very, very small number of potential long-term rentals if those were sold. If you look at the short-term rental map currently, there's already very few properties that would be eligible with the existing 250-foot rule. We wouldn't really have much growth even with the existing rules, so it seems like you're changing the rules, and the benefit is very questionable. I would like to hear about the nuisance aspect and the numbers for calls to short-term rental properties compared to every other property calls for police service. Thank you.
Thank you. Okay, I'm going to move on to Janelle.
Hi, can you hear me okay?
And thank you.
Okay. So my name's Janelle. I do not live in Sisters. I work there. So I have a few questions. Has the council considered the potential decline in transient tax revenue that could result from limiting short-term rentals? Additionally, I would like to understand what specific nuisances these rentals have caused. As a property manager, I've not received any complaints or notifications of issues from neighbors or the city, despite having my contact information readily available. Have you examined the average salary of working families and the rental prices in Sisters? The notion that these homes would become affordable with these restrictions seems a little misguided. Would it be possible, or would also be informative to compare the number of nuisances reported from hotels in the recent years? I mean, the majority of our guests are families traveling to Sisters to create family memories, which is something that we promote. So it's not people out for a girls' weekend. People aren't coming here as a alternative to Vegas, that's for sure. Lastly, has the city council considered the impact on jobs that the short-term rental industry provides? The employment, the local business support, the money that people spend during the summertime when they travel for events. Have they looked at any of that, how that will be lost if we cut back? Because I've looked at the map. So if you expand to a 500-foot buffer, you're basically eliminating short-term rental options. And then as some are eliminated, as people either pass away, since it's been noted that it's not as transferable if somebody passes away as initially thought. So if that happens, or somebody ends up having to sell their home, and those licenses fall off, that's less visitors to Sisters. That's less money being spent in Sisters. Long-term tenants in Sisters don't like spending $15 for a pound of strawberries at Ray's. So often they go to Bend or Redmond for grocery shopping, or for shopping, period. So I'm just wondering, has those details actually been looked into? Thank you.
Thank you.
Okay, the next person I'm going to call on is Sally Gray.
Confirming you can hear me?
I can hear you, thank you.
Great. I did provide written comments this morning, but I actually went through the documents that are on the website, and I've read every set of minutes that have been produced and all the hard work by the city and all of you to get to this point. So I did a little bit more research, and I have 2 additional comments. As background, we own a condo at Four Sister Lodge. We've owned it for 20 years. We're a long-term owner, and right now we are not renting our property. We actually became a property owner after visiting it and renting from it. So there is a benefit for exposing the greater community to Sisters that sometimes eventually wants to live there. But even though we don't currently use it as a short-term rental, this proposed change does have a restrictive impact on our property especially as we're looking at higher taxes and higher HOA fees. So I wanted to do my two comments. The goal of increasing one of the goals of this seems to be increasing long-term rental availability. And I probably, as other people have said it, it's not really clear that will have that impact. We wouldn't probably at this point do a long-term rental, but I just would want that examined more closely, or analysis from other areas that have limited short-term rentals, if they've had an impact with long-term rental increasing. And then secondly, there hasn't been a lot of comments about specifically condominiums. So, that's my perspective, and it does seem a little bit different because it is it is already dense. So Four Sisters Lodge has 28 units. Yes, there are some that are already in the short-term rental policy. If you were to start over though, and add those 28 units, only one short-term rental could occur in those 28 units. So then I looked at Google Maps and I said, we're 500 feet. Oh, there's 20 houses surrounding Four Sister Lodge that are now impacted by this policy. So you have 50 homeowners, 50 taxpayers, 50 tax lots that are now being impacted by this policy by the 500 feet. And so the policy seems to unduly penalize a condo owner versus a residential. I don't know if in Sisters, a residential community would, with one STR, would impact 50 neighbors. So I just wanted to expand on that point, the difference that a condo is to the rest of the buildings in Sisters. And then lastly, I just want to thank you again for this process, for the staff and the staff prior to this meeting answering questions that I had by phone, and their strong work today. Thank you.
Thank you. Okay, last call. If anyone attending over Zoom would like to raise their hand, there's a button at the bottom of your Zoom screen where you can do that. Seeing none, maybe we give some people in the room another chance if they didn't get to speak.
Is there anyone else in the room, whether you've given us a slip of paper or not, who would like to speak? Come on up. Just state your name and your address for the record, please, once you get up to the microphone.
Thank you for allowing me to speak last minute. Name is Shane Reamer, 249 West St. Helens. My background is city and regional planning, real property minor development, also retired general contractor. And it appears to me that this may be an opportunity for this new code to change the current code for those existing homeowners that have short-term rentals. And I would be highly against any modification to somebody who already has this in place to their property, that they came and moved to this city knowing what the current code was at the time. They purchased their properties at that time knowing the code and the implications of it. And I don't think it's fair and reasonable that as a city or as other residents within the city to go ahead and modify something that's already in place. To put limitations to people who are going to be buying in the future, I could foresee that and understand that. With regards to affordability and housing, I did plenty of case studies when I was in college and so forth. But from my lens, this does not address the affordability of housing within Sisters. I do believe that affordability with housing within Sisters can be addressed through future development and fees that are imposed on developments that should go ahead and cover the cost for low-income housing. I also see how many apartments have gone in the last couple of years that are in Sisters. So it does look like there has been a significant amount of affordability within Sisters. The other thing is the short-term rental does provide affordability for those that own those homes. It provides affordability by additional income, whether they're retired or whether they're in transit from having children to being single, empty nesters and so forth. And I think putting limitations to ways to produce additional income, and I think tonight it's been mentioned as well for property taxes and so forth, which don't really have a limit here in the state of Oregon on a percentage basis. So as we age, our affordability to be able to stay in our homes actually goes away. And so for those who already have a short-term rental, and if you take that away from them, and I think even the transfer of that taken away, I do believe personally that if a short-term rental is currently licensed, that it should be able to be transferred. I have looked into it before in the past as well. And when you take a radius of 250 feet, it really becomes 500 feet, right? Of within your area. And that's quite a significant difference. When I came to here, I would have thought that 250 feet would be on the actual street line of sight, not going within a radius. When I've looked at other municipalities throughout the country, I've seen case studies and so forth where that 250 is done within that specific street. It doesn't go ahead and go to afford to a radius. And when I've called to the city before to see the availability on existing rentals right now, it's extremely limited. So it doesn't really make sense why we would extend it to 500 feet and limit even that much more so. And I would also state that there maybe needs to be consideration to who are making the complaints as far as the concerns with the current short-term rentals, and even looking at the potential enforcement of what's going on with those short-term rentals. This may be an enforcement issue, not so much a limitation issue. And it also may be that we have people who are living next to a short-term rental that's already been approved that just don't like being next to a short-term rental, and they bought there. We had friends come in here and visit for mountain biking for races here recently and stayed over in Pine Meadows, and their neighbor was all over them. They were not even able to enjoy their short-term rental. It was a miserable experience. She was knocking at their door right at 9:55 to tell them to turn off their outdoor lights. And that's not what we should be displaying to people who come and visit this city. That is not, I think, who we are as people or should be as people. We should be inviting people to come here to visit. This is a city that surrounds tourism. I grew up in another small town that was based on tourism. And I think it was brought up tonight too, as well as the affordability to be able to rent a short-term rental. If you look at a family that comes here and visits, and it's a family of 5, to be able to find a hotel, now you're looking at 2 rooms. And if you're staying over at Five Pines, it's probably $1,000 a night. If you're staying around the corner here, it's $400 a night for one room. So if you look, it doesn't create the affordability, and that goes ahead and pushes down to everybody else. So we actually end up having less visitors, less people moving through here. And the reality is I think people who visit short-term rentals, they're not there for the most part to make trouble, in my opinion. They're there to be able to enjoy the town. They generally are families. They're looking at short-term rentals because they're single-family dwellings, and they have the availability of multiple bathrooms, a family environment, and so forth. And we're actually taking that away from visitors. So I would highly oppose any modifications to what's being proposed to this evening, and take it really into consideration that this is not a means of affordability. This actually does the opposite, in my opinion, and it doesn't really resolve the affordability within Sisters. And I think the other thing to take in consideration of Sisters is all of us who live here in Sisters moved here based on what currently Sisters is, not what it's to be. And so looking at it from a planning perspective of, even with, it's a side tangent a little bit, but even with expanding the urban growth boundary, is that's making modifications to what Sisters is and what we all moved here to be and what we loved about Sisters. So the question I would propose to the commissioner tonight and to the board is, why are we modifying the town that we came here and loved to move here to? Why would we want to do that? If people love Sisters so much, there's other opportunities within the country to grow if they really desire to grow. But why would we modify the town that we came here to love? And so that would be my encouragement, is really reflecting back on, why are we here? And we're here because of Sisters as it is now, and why we would look to change that. And I think that there could be case studies around the country. Your Ray would be an example that I would use in Colorado as an example versus Telluride. If you look at Telluride and your Ray, the growth boundaries and how those two towns have developed and changed is a significant night and day difference between the two. And really doing the due diligence rather than just looking at it, what does this do for revenue? What does urban growth boundaries do for revenue and taxes within the city? And do we really focusing on the right directions of what's best for the community, not necessarily what's best for certain individuals in a limited opportunity? So thank you.
Thank you. Is there anyone else who'd like to make any comments who's not yet had a chance to do so?
I'll check Zoom one more time. I'm not seeing any more hands up.
Okay, questions of clarification? Do any Does any member of the planning commission have any further questions of staff? Commissioner McGougall, you look like you have a question.
Honestly, I'm thinking I would like some more to drink.
Oh, okay.
Sorry. Apologies.
I guess I have a couple questions that I'll probably, that were kind of sparked by the public testimony. Did we consider exempting, or did the city council, I should say, consider exempting or doing anything with regard to owner occupied STRs? I can't recall offhand.
Yeah, so that was discussed at the planning commission level, the idea of what I'll call hosted short-term rentals, where the occupant or the owner was on site during that time period. We did carry that forward to the city council, along with the idea of increasing the number of days required to be rented. And after discussion, just city council chose not to take that direction at that time.
And do renovations or add-ons, I think a gentleman mentioned that tonight, that sparked a question for me as well. Does that affect their STR status, or how does that play in? Does that not really?
As long as any renovations or additions to that structure, as long as it remains a single dwelling unit, that would not affect the short-term rental operation at that property.
But if it became 2 dwelling units, then that 2 apartments, for example, that would be affected.
It'd be limited to the 1 dwelling unit that was approved.
Okay.
Unless the concentration limit doesn't apply to a mixed use structure. So like, let's say it's a mixed use building, commercial on the ground floor, 1 residential unit, maybe they add a 2nd residential unit, but it remains mixed use. Then that might still be not restricted from concentration.
Thanks.
Thanks.
I have a question. Let's see. In the prohibited uses on the first paragraph of this new development code. Number 2, and it's notwithstanding is the way it starts. At the end, it says the effective date of ordinance, unless specifically permitted in an annexation agreement approved by the city council. Can you give me an example of that? How that would work? I own a piece of property. I guess I'll just ask the question. I don't own a piece of property. Let's suppose I own a piece of property in the urban growth boundary, the new one. It's not in the city limits. And I want to get it developed. And so the agreement I make with the city then is I want to be able to have short-term rentals in my chunk of property when it comes into the city limits.
Yeah, so within an annexation agreement, there's opportunity to have conditions that go beyond what our development code may require or allow. So a scenario could be, again, we're pulling straw. One idea is that if as part of a development, again, not looking at the feasibility of a scenario where a property owner or developer were proposing to have an increased number of affordable dwelling units within their acreage that's being brought into the city limits, with a condition that they're allowed to have some number of short-term rentals within that development. So that's a kind of an exchange of we're offering X number of affordable units, but at the same rate, we'd like to.
I'm trying to understand that. What do you mean by the development wants to offer affordable units? So we have to, because they're going to use them as short-term rentals?
No, so I mean, again, we're creating a scenario on the fly that say they want. Let's go to an extreme that they want to provide 75% of the acreage, and then the units are affordable, by definition. That's a well above and beyond what a minimum requirement would be in our code. But the exchange, so to speak, would be an allowance that some number of short-term rentals may be allowed within that acreage, in a not exchange, but as part of an agreement to provide that level of unit. There could be a development that comes in that is more of a contained, what I'll describe as a kind of a resort environment, that has a an aesthetic, a feel, a component that would warrant allowing short-term rentals as part of that development. So the idea was, again, that we're looking at annexation areas that are sometime in the future, 5, 10, 20 years down the road, and not knowing what the conditions were within the community, the interests of the community at that time, and providing an opportunity for a council that is sitting at that time to have some flexibility with these new lands.
Matt, in terms of going to 500 feet, I've been involved with this from the time we first came up with the idea of the 250 feet for short-term rentals. Is that the city council recommendation to go from 250 to 500, or did we, I can't remember if we recommended to go to 250, from 250 to 500, one of our work sessions.
Yeah, it wasn't specifically from the planning commission. It was if I would look at the notes, but I recall it being the city council that initiated, but let's start looking at this and let's analyze what expanding it to 500 feet would be. So it came out of those initial discussions with the city council. It started with the question, do you want to consider expanding the concentration limit? And therefore, if so, I should say, to what extent do you want to analyze it? And they landed on a 500 foot to be analyzed. I think that's comparable to what other communities in the region had considered. Particular City Bend was the most recent community that's kind of gone through a similar process.
I just wanted to speak to your question, Commissioner Reeves, just to add a little bit more background, what Matt offered. I think the intention of the provision in the first place from council was that, our expanded areas that we're looking at with the urban growth boundary, are being targeted or looked to as providing a reasonable or high proportion of housing for locals. It's an opportunity area for housing for locals. And I think that the intention was that there be a limit or outright prohibition on short-term rentals. The thinking being that short-term rentals are kind of contravention to affordable housing and the goals that the council stated out there. But I think the provision in there was just, as Matt had said, is just to provide council that flexibility if there was a unique proposal that would warrant allowing short-term rentals in limited situations. But I think that I just wanted to offer that I think the council's position was that their opening position is that they would not be allowed in future annexed areas because of the real desire to make them more oriented towards locals housing.
Yeah, it seems like an interesting kind of loophole to me.
And it may not pass muster with council. We don't know. It may not pass muster with planning commission. It's all open for discussion.
It seems theoretically that even if that weren't in there, a future council could add code to allow themselves to, or a future council. I mean, it's not.
They could amend the code again,
I
direct
kind of
staff
feel
to
like
amend the
there's-
code again if they
yeah,
wanted to.
Yeah, it kind of feels like whether it's there or not, there's probably the same opportunity.
Correct. It would be a little bit more of a process, but yeah, you're correct.
I have a question.
Commissioner Russman, did you have a question?
Yes, I do. In our deliberations, I'm coming halfway through the whole study for short-term rentals. But in regards to the increase from 250 feet to 500 feet, a lot of questions have been asked about condos, which are high-density housing anyway. Have we considered, rather than doing a footage restriction on those high-density housing units, to do a percentage like 5% and no more, that kind of limitation as opposed to footage?
Yeah, so that was one of the options originally considered when we initiated the project was some type of cap, either number of or percentage of dwelling units within the city or a numeric cap of short-term rentals within the city. So that was initial consideration. It just did not elevate as a priority as from direction from the city council.
I was referring not for overall rentals in Sisters, but just on those high density units such as condos.
Yeah, so the answer is no. A particular percentage or other specific to condos or multifamily developments was not considered.
Okay, thank you.
So when it has to do with condo areas, it's no matter if you have 4 condos or 20 condos, it's 1 condo in the complex.
Yeah, condominiums are a ownership mechanism of a multifamily development. So apartment, condo, we look at those the same. So yes, it'd be limited to one. I mean,
Unless they were 500 feet apart.
exactly.
And with a condo, that would actually be within the condo unit itself, or does that come from the property line for the whole condominium unit? My understanding of condos is that they're. Oh, that's the end of my question, sorry.
Yeah, so it'd be measured, from the edge of the common property. So the ownership of the unit is just that, and it's within a building. But the development itself includes that, what in most cases is a common area outside of the building.
Gotcha.
No more questions for me.
Any other questions from commissioners?
I'm struggling a little bit. I think that comparing us to like Bend is not, we're really concentrated in terms of the distances between buildings here in Sisters. We don't have a big footprint. And so if you go 500 feet, it's making a lot more difference here than it would in Bend. And so I don't think it's apples to apples there.
It sounds like maybe we're ready to head to deliberations. Is that kind of what that?
I guess that's a comment, not a question.
Vice Chair Dickman, if I could just, before you get into that,
Sure.
I just wanted to just
Please.
briefly address some of the comments that came up about, the impact to lodging taxes and the impact to jobs and those kinds of,
Thank you.
secondary things. And they're great questions. I just wanted to note that, those are more the purview of the council to consider. They're the ones that control the purse strings and the budget and all that. And those are policy considerations that they'll have to make once this comes in front of them. I just wanted to clarify for the public who raised those issues is that those are good questions, but they're not the really the domain of the Planning Commission, which, is limited to, more the criteria in the code. So just wanted to address that to make sure that you felt like your questions were being addressed. I think those are good questions to bring up once this goes forward to City Council.
Thank you. All right. If there are no further questions, I will close the public testimony portion of this hearing. Going once. Public testimony portion of this hearing is now closed. Planning Commission deliberations. We have now closed the hearing. And I think I have a request from a commissioner to take a 5-minute break prior to beginning our deliberation. So we'll come back here at 7:05 for deliberations.
Thank you.
Okay, picking up where I left off, the Planning Commission deliberations. We have now closed the hearing and must deliberate towards a decision. Our options are to recommend to the City Council, A, approval as proposed, B, approval with changes, or C, denial. The script says when your name is called, please provide your thoughts on the proposed amendments and what decision you are inclined to make. I will continue going through the order until there are no further deliberations or until a motion is made, so you will have the opportunity to respond and or adjust your thoughts based on the testimony of your fellow commissioners. I'm just going to copy Jeff and say, I have a kind of a casual-ish conversation up here about our thoughts. And please feel free to pipe in there, Commissioner Rutzman.
Okay, I'll start. I like the whole idea, but I would like us to consider, again, for those high density multifamily and condos, instead of doing a 250 feet, to do a percentage, so that it just seems like it would balance things out a bit.
And my comment would be, I don't like the 500 feet. I think we're too concentrated here, and it basically eliminates any further short-term rentals, period. I think 250 was a pretty good number that we arrived at originally.
So, I have a comment. So I know that there are some things, brought up tonight about complaints and nuisances and, also about, I lost track of the other item, but I think that in my mind, or the lens I look through, is that this isn't, about fixing like the housing issues we have or trying to provide more lower cost housing, but in general, like short-term rentals, the issue with them, if they go too far, is that it takes away from community. And if we have, so the reasoning isn't only about, are short-term rentals good or bad? It's about, do we want to keep neighbors? Or do we all want to live next door to something where you have changing neighbors? And so I just wanted to share that that's the lens I'm looking through this with, as opposed to them being nuisances or there being that type of purpose for making any changes. I definitely, I understand that the commission did raise up to the council for consideration previously regarding making some kind of allowances for hosted rentals. I still stand in behind that thought. I think that's a whole different situation than having an either an empty unit or a full unit, and that as Mr. Bennett testified, it doesn't present a difference in a community when someone is coming to visit them that's a friend or someone that's renting out part of their house. I see that as a very distinct, different type of situation. I realize we raised it before, but I just feel like I had to say it again, that I'm still behind that particular type of wording. I do have a concern with a few of the situations here. The section F did concern me, where I guess if reading through it, it feels like if somebody were in a will and a house were given to them, it's going to transfer ownership, but it wasn't sold. I mean, I feel like that's a situation that may not be covered there, and it makes me uncomfortable. So I'm not sure what we could do about that situation. I would like to see if there's some kind of recommendation we could put forth there. And I also have a concern.
Is that, I'm sorry, I didn't mean to interrupt you, but is that already, that was pre-existing code language, I think? Is that?
Where is that?
Yeah.
I'm sorry.
In the section F.
Yeah, where Commissioner Reese had asked the question earlier. Transfer, reading through, if the owner dies there are only certain changes in ownership where the short-term rental license can be passed along. And it seems that if, you know, we're a grandparent or some other, or friend, it feels like we're trying to define what family is here, of who can it pass along to. I mean, somebody's aunt could just as soon be their mother figure. I don't know.
It only applies if it's after 2018, I guess, because if it was before 2018, it is transferable anyway.
And I think one of the things I would note is that just if we're here to consider changes in the code, the changes are the underlying portion, right? And I guess, I don't know, we're getting too far afield if we go in and change sections of the code. I guess in how they function and operate with each other, maybe we can,
Oh, you're right.
I don't
And
know.
now that you're saying that out loud, I appreciate that. I do
I don't-
make that, I
I
appreciate
see,
that.
your point is
I
a
had
good
not,
one, though.
it was when Commissioner Reese brought it up earlier, I was all of a sudden just feeling very uncomfortable with the code and had, sorry, lost track of the fact that that was old code. I do apologize for that. I guess I'll take that up some other time. And not that this is a laughing matter, but we're all humans up here and, you know, every night we're here, it's a different situation and we're just doing our best to
You
get
don't
through
need to
it.
apologize for
No,
that.
no, I just, it's a strange situation sometimes. I do have concern though, it sounds like there are a few situations. Well, I guess it's, when people make business decisions, you know, there's always risks and I do, understand that some of the series of coding changes that may have happened in the city may have caused strange exceptions where assumptions just wouldn't apply anymore. You know, the gentleman who testified, who may have started in the downtown commercial district, which would have previously possibly been commercial zoned, and now it's residential and different rules are applied. And if, I mean, that's what I was tracking and that made me uncomfortable as well. Did anybody else have that?
My problem is with like specifically people who bought a condo and believe that since the rules that were passed in 2018 would allow them to not be included and be able to transfer ownership so that they, oh, I'll buy this because I can sell it in 5 years if my kids move away or whatever. And then all of a sudden the value changes because you can't have a short-term rental there anymore.
Right.
And so,
That's another one that I also felt uncomfortable with.
yeah, it's kind of after the facts
Yeah.
stuff that, you know, affects people's future.
I find a little bit of a difference between obviously someone who currently has an STR and we're proposing code changes that will remove the STR from them. That feels way more unreasonable, a mile more unreasonable than the sort of the prospect of, well, I thought I might want to sell this to someone who might be thinking of this as an STR. That feels like such a degree removed.
But we're not removing, everybody's grandfathered in that has an STR.
Right, but it's someone who has a condo that is not currently an STR. I think you were citing the issue with selling it to someone and.
No, I was saying somebody who has a condo that is an STR and bought it.
Oh, as an STR.
Under previous rules, knowing that they could sell it and transfer the STR, now they won't be able to. So that changes the value of their unit. That was.
So this doesn't eliminate anybody who has an STR from having one.
No, but it eliminates them transferring it if they had a condo, because before condos weren't included, so they could, now they can't.
And from my understanding, a lot of the complaints, the pushing came from the citizens to the city council saying, you know, we do not want to be a community or that has lots of STRs where they're everywhere, like communities, resort communities around the country, and where the city councils are having to put their foot down and pass ordinance that are really pretty strict after everybody has an STR. Not everybody, but a lot of people. And so I think the city council is trying to get ahead of that by doing this.
But we did, or previously, when we made a 250-foot.
Yeah, oh, completely.
Yeah.
Right. And I think that's the reasoning is that the citizens who are talking to them at city council meetings are still pushing that issue. I'm not saying it's right or wrong. I'm just saying they're still
Yeah.
pushing that issue.
Yeah, I understand.
And so, I don't, one of my biggest issues of this, I don't have a problem with the 500 feet, is with the STRs where the owner is occupied. I'm renting out a room and I'm there and I'm not going to put up with a party in the room or the back of the house or my alternative
Additional dwelling unit.
additional dwelling, as opposed to I own a house or I own 2 or 3 houses and I'm going to rent them out to people. And if it doesn't make any difference if the enforcement is bad, it still becomes a problem if there's one of those.
But that could get really complicated because what if you have another place somewhere else and you're gone for 3 weeks and you rent it out and then it's no different really than even though you're a
No,
resident.
but yes, but I mean that, so that I understand that too. Oh, I own a place and I'm gonna rent it out for a week and I'm gonna take a vacation and I don't care, you know, I'm gonna be gone, so nobody can contact me. So it is interesting that I don't know how the city council would tell the staff to write that into a code where
Right.
you have to be, the owner has to be there
It could be pretty
24/7.
Right.
I don't know how you write that, but that would be my concern. And I also, I understand what staff says about the city council and an agreement, an annexation agreement. That's an interesting take on it, but from the standpoint of, we don't want short-term rentals. We want them 500 feet apart, and then we're gonna annex a chunk of land where we're gonna allow them, seems kind of hypocritical.
Was the proposed language is prohibiting them, right?
It was, except for a special circumstance, basically, where the city council could could allow it.
Yeah, so I'm not, I don't care for that.
Do you want to take out you
I-
don't care for the loophole that allows the
Yes,
city
I don't care
council
for
in the
the
future?
But the city council could do it anyway.
I'm not saying they couldn't, because I know how I've watched how the system works. But if it's in there, it's in there, and so I'd rather it be out of there, and I'd rather have the city council then have to go through this process and agree to a change in the code for an agreement. That's my feeling. My other comment is, this is a general comment. It's an interesting dilemma that we are in. We are not elected officials. We're appointed because we volunteered. We're not part of the city council. We're not part of the planning department. We are here because 50 years ago, the state law passed and it said that every community, when they're doing these kinds of things, will have public involvement. And we are the public involvement. We're the ones that are asking questions. We're not in cahoots with anybody. And that's, sometimes we get in this situation and I feel like, you know, the community doesn't know that we're part of them. We're not part of the system, and that we're just trying to do our best and try to keep tabs on making sure a loophole doesn't slip through. And so, I could okay it. I could agree to it, without the annexation, the annexation agreement part. And I wish the city council would talk to the staff about how can we list the difference between owner occupied, renting out a room in my house versus I'm renting out my house. And is there a difference? So maybe you know, can I have own a private home and it can be short-term and long-term? I could.
Yeah, you could have a place and split it up and have permanent residents in part of it, long-term, and then designate a couple rooms for short-term.
Or I could
if you
just
wanted to.
own another house and I could rent it out, get a short-term rental and rent it out for 30 days or less if I wanted to, but also I could say, or you could rent it for 5 years or 2 years.
You could. Financially, it seems like short-term rental, the revenue is much higher than a long-term.
But there is no, I don't have to get a license for a long-term rental.
No.
Commissioner Retzman, I don't want to leave you out in the cold here. If you want to jump in and add some comments, please feel free.
Rick,
Whoops,
just
I was
so you're-
muted there.
you go.
My comment was just about the high density housing. And I'd like us to consider making it a percentage as opposed to a footage restriction on there. So I've already stated mine.
What do you mean by a footage restriction?
Well, right now we're talking, going from 200 feet to 500 feet. That's a footage restriction. Where on condos, that could take away the entire building or the complex away. Where by doing a percentage, you could have a couple units, maybe, where you have a 30-unit condo, maybe 2 of them short-term rental. That's what I was referring to as a percentage, as opposed to the footage restrictions that we're talking about.
I feel like I'm hearing that the condos are a point of contention.
I think several people have brought that up as an issue, yes.
It's just speaking in terms of the commission alone, because we have to come to a vote at some point. It sounds like, Art, sounds like maybe you have kind of an issue with the.
Yeah, I think it is gonna if you have like 30 units and there can only be 1 unit that could be a short-term rental. It seems kind of silly to me.
For my part, like I don't dismiss the housing affordability argument here as quickly, I think, as maybe some others do. I find that, and in particular with condos, where you're talking about a volume of, families or individuals who could live and perhaps work in Sisters. I mean, that's increased significantly by condos, whereas as a lot of other people have pointed out in comments that, if you have 250 feet or 500 feet in a town as small as Sisters, maybe you're not adding that many single family houses. You're not adding even maybe any duplexes or triplexes but with condos you are. I'll admit to being kind of conflicted on that though. That's, you make a good point about the, 30 unit condominium and having one condo in there as an STR.
Yeah, who's the favorite, the
go
golden
500.
child there gets the.
So this pertain to a fourplex, a townhouse fourplex, or a sixplex.
Yeah.
The way it's written now, you'd only have one, no matter whether it's a fourplex or 30 unit or 50 unit or whatever, you can only have one.
And that's why I suggest something like 5% or 10% as a percentage, because if you have an 8-plex, you're not going to get 10%, that's only one unit, so that's why
Well, so the prior, sorry to interrupt, but
no, that's it.
the prior code language did indicate just 1 unit, correct? I'll reach out to staff real quickly just to make sure I'm reading this correctly. Only 1 dwelling unit on a property with ADUs, duplexes, apartments, condominiums. That would include, I assume, triplexes, quadplexes, all that.
Correct.
Just 1 unit per block.
No, I thought condos were excluded
Well,
previously.
Well, where they were regulated through the concentration limit, it was 1 dwelling unit per property. But
They're not regulated.
But currently they are exempt from the concentration limit now.
See, that's what.
Okay, I see.
So you could have either, 1 or the entirety of the complex.
And that's what I was talking about, transfer of ownership and things, because
Right.
it wasn't regulated.
Well, maybe we should go through the ones that we do agree with. It sounds like we have a little bit of a contention here with the residential districts located in areas annexed into the city in the future, unless specifically permitted in an annexation agreement approved by the city council. I mean, I'm kind of okay with that language for the reasons Commissioner McDougall stated, and that a city council theoretically could come in and kind of do what they want. And so whether we have that language in there or not, it's sort of implying what's already kind of an unspoken rule anyway, is that a city
Right.
council.
I'm okay with it.
I'm not okay with writing in a loophole.
Okay.
Or not, I'm not writing it in. I'm more interested in taking the loophole out.
Okay.
And if the city council wants to do that at a later date, they can do that individually for those individual people trying to get into a annexation agreement, I guess.
And then the concentration limit itself, disregard for a moment condominiums. Are we okay with 500 feet instead of 250?
I'm not.
Even with regard to houses, duplexes?
I thought 250 was fine. I don't understand. I think there's pressure on the city council to do something and they just doubled the radius. And since Sisters is so small, when you do that, you basically eliminate everything.
Well, I think the people that probably complain the most are the people who've been next to ones where they've had problems. And
Can you speak into your microphone? I cannot hear you.
I think it's because the city council has heard from homeowners who live in town and they have complained about short-term rentals making too much noise and I would not care to live next to a unit that was a short-term rental. I just wouldn't care to. Anecdotally, when I went with my family to the Palm Springs area, the property owner made us sit down in the living room and he told us all we had to sign this paper that said, because the city council there passed a new ordinance, if they get called, a police gets called to your place where you're renting once, the homeowner gets charged $1,500 fine and you have to agree to pay it or they won't rent to you. So apparently it's gotten that bad in places, and I think the city council is trying to stop it from getting bad.
But that's an enforcement issue, not the.
And I think the issue for Sisters, yes, it is an enforcement issue, and I think the city doesn't know if there are short-term rentals out there that are going under the blanket. I'm not going to get a permit. I'm just going to do it. And so unless somebody complains, because nobody comes to my door and says, excuse me, Mr. East, do you have a short-term rental upstairs? Which I don't.
So you're okay with the 500?
I'm okay with the 500.
And Commissioner McDougal, you're okay with the 500-foot limit too? I think Commissioner Retzman voiced that his only complaint is including the condos in the 500-foot rule as opposed to. Sounds like Commissioner Retzman, you might be in favor of keeping the language as is for condos. Is that your point?
Complaint really wasn't the right word. It was concern, really. Your question about keeping the language, can you?
Well, right now the language, it accepts condominiums, apartments, duplexes from the concentration limit, I believe, such that it's one dwelling unit regardless of distance is the current language, correct? Am I reading that? Yeah. So you're not in favor of changing that to a 500-foot rule?
Correct.
So not including condos.
I think what I'm hearing Commissioner Retzman say is that I get a little confused with the red lines and underlines, but I think that ADUs, duplexes, and apartments are part of the current code, and condominiums were added in. And that Commissioner Retzman is saying that condominiums are different because there are a much higher in number. And so condominiums might be better served by saying something like only 20% could be
short-term rentals.
Short-term rentals. Am I hearing you correctly?
I would go with even a smaller amount, like 10%.
Yeah, no, I'm sorry, just the concept.
Right, but conceptually, yes, that's what I'm saying.
Okay.
Kind of a fractured group right now, I think a little bit.
I could agree to that, 10%.
Yeah, that'd be
But I
better.
wonder if a
That'd be better.
10% is workable if you have 9 condominiums, 8 condominiums, so you get 0.8 of a condominium. I don't know.
Right.
That's
Yeah.
why sometimes for voting purposes here to decide, it sounds like maybe we don't like that language. I'm okay with the language personally. I could be okay with 500 feet with the condominiums personally.
I actually, Vice Chair Dickman, um, agree with what you were saying earlier about condominiums. I do believe they're a little bit different in the way of looking at, I'm not going to say affordable housing, but less expensive housing.
Right.
And they can be an entry point for people. And so, you know, if all of our condominiums are obviously, you know, we're going to grandfather in everybody now, but if all of our condominiums are used up as short-term rentals, that takes out a lot of entry level housing. I mean, I understand they're still expensive, but they're less expensive. So I agree with leaving them in.
And then for the section F, limits on permit transfer. The only language we're considering is to continue the short-term rental use after transfer. The transferee of such real property must file and receive approval. So basically, you have to, when you transfer, you are under the new regulations.
Yes.
Sounds
like you guys all agree on everything pretty much. I'm the odd man out, so.
Well, I think Commissioner Retzman might be with you, Commissioner Blumenkron, when it comes to condominiums.
Well, he wants a percentage of them to
Well,
be.
I said as an option as opposed to the 200 or 500 feet, you know, that's something to consider. Maybe it's a number of units per, I don't know, but 500 feet seems a little bit harsh for a condominium because you do something like the fourth sister, and that would only be 1 unit in the whole entire complex could be a short-term rent.
If I may, I think an opportunity, kind of speaking of condos, as you wrestle with that, just acknowledging that any of these changes would be applicable to new applications for short-term rentals. So those that were either pre-existing, the pre-2018 or after, you know, those that are in place can continue to operate. So theoretically, again, if we're using fourth sister as an idea, if 10 of those are there, they can continue to operate. It would be just if someone were to transfer that property, a new owner wanting to pursue a short-term rental, if that approved as proposed, they would not be able to. So you'd lose one through that transfer and so on for those that fall within that limit on transfer window. And another opportunity, I think what we have, you know, what I've couched this is kind of 4 distinct aspects of the proposal. And, you know, I understand that we have divergent opinions and we're trying to get close. You know, what we're trying to get to is a motion that could carry. So I think maybe we could, those 4 distinct aspects of it are 1, the prohibition on short-term rentals, whether or not the group or the majority would support that as drafted. Then the increase of the concentration limit to 500 feet. The applicability of the concentration limit to 1, condos, And then two, the applicability of the concentration limit to residential only developments in the downtown commercial district. Those are the four distinct aspects that have kind of substantive aspects of the proposal.
Okay, yeah,
So
helpful.
perhaps there's an opportunity to kind of see if there's any common ground with
I mean,
those.
I would be good with the motion for accepting it, unless specifically permitted by an annexation agreement.
I cannot hear you. Can you speak into your microphone, please?
No, I cannot.
You have a hearing aid, Rick?
But no, it's just, it's really quiet over the microphones don't pick up very well unless you eat the microphone.
You know, and not to interrupt, but I think there's an opportunity if we can, if there's those distinct elements of kind of that you really wrestled with, that we could recognize that a motion carries, but there were some other elements of it that really felt like needed some additional discussion or thoughts on. So
Yeah, so the downtown commercial district issue, I mean,
I don't have a problem with that.
I'm fine with that as well. I don't-
Yeah.
Okay.
Okay, one
and,
down.
the transfer language for me works.
Fine with me.
Yes,
Yep.
I'm good with that.
Okay, great. I'm personally okay with how it is written in terms of the UGB, the potential expansion of the city limits of Sisters. So D sub 2. And we're unanimous so far. So if you want to weigh in with a dissent to strike some of that language, obviously, Commissioner Reese, that's your prerogative.
Well, if a majority of the people of the commission wants to keep it in, I'm not going to make a motion to kick it out.
Okay.
So, I'm for kicking it out. And so you'd have to ask the rest of the commissioners how they're kind of thinking.
Yeah. I think Commissioner Retzman doesn't have a problem with that. I don't want to take words out of your mouth, but future annexation to the city limits, just prohibiting them unless the city council.
Yeah, I like equality across the board, but I could agree with that one too.
Commissioner Blumenkraw, you're okay with that one?
Yeah.
Yeah,
I'm
okay.
The city council is gonna do what they're gonna do.
Yeah.
anyway.
Okay. So I guess the one area where the discussion has kind of already been had, but maybe we need to drill down to what the brass tacks are is with condominiums. You don't like the concentration limit of 500. You want to keep it at 250, right, Commissioner Blumenkraw?
Yes,
Um,
but again, if I'm in the minority and you guys are all gonna say 500 is okay, doesn't matter what I think.
okay. I'm personally okay with the 500 foot.
So am I.
We're gonna grow. Sisters is not gonna remain the same. Seems to me that in the future, we're gonna have a broader, bigger town with more units and the idea-
Except for those new annexations will be exempt.
Right.
So what you're saying really doesn't really hold true. Yes, we're gonna grow, but it doesn't really matter if we grow because the new growth won't be included in the short-term rental.
Well, they'll be
Cool.
prohibited.
Right.
Yeah.
Right.
Which I'm okay with too.
And again, like I don't hand wave the affordable housing aspect of this or just the housing quantity itself. Not everything is affordable. I'm reminded of hermit crabs that they go from one small house to a bigger house to a bigger house, and then that weaves around and there's more housing for everybody ultimately. It's kind of how I view it. I don't know.
I think the only issue then really boils down to does it seem reasonable to everybody that you have a condo development and we're gonna apply the 500 feet, then yes, the ones that are there are grandfathered in. But you're only gonna be able to, eventually you're only gonna have one unit as people
Well,
sell their units.
we can look at it also, like, let's pretend we're building a new one and there's 10 units. Like what would you want to see there? I mean, I realize we've got some pre-existing,
Well, if you build a new one and you're within 500 feet, you can't have any.
yeah, but I mean, if we did want to go to the percentage,
I think it would be up to the HOA. I think the HOAs, the homeowners associations decide whether they want any short-term rentals or not. And there are some that may decide they don't want any short-term rentals, period. And that trumps whatever we say. If the HOA decides they don't want any short-term rentals in their neighborhood.
I don't know if I want to assume that an HOA is going to do one thing or another when thinking about the code personally. I'm personally okay with, if I had to be forced to a vote, I would be okay with the language as proposed. And so but I don't want to, again, make a motion when it sounds like we all, tracking this conversation correctly, we have a motion for that wouldn't carry.
Well, I think it would because
It may not carry unanimously, but I think it'll still carry.
it'll still carry.
I'm
Eh.
okay with the condominiums. I was just trying to present
Yeah.
an example because I think we may have our heads in the old example, the complicated current situation as
Yeah.
opposed to what would happen if there was new building. Yeah, but I'm okay with the wording as is proposed in E2 here.
So if I mean, just to kind of provide some kind of observations,
Mhm.
commentary on the
Please.
discussion. So if what's been the notion of a motion to approve as drafted, I'm seeing that we'd have one dissenting vote from Commissioner Reese regarding the prohibition language, and then one potentially dissenting vote from Commissioner Blumenkron regarding the 500-foot concentration limit. I guess that, I mean, we're not getting ahead of a vote, but that
Yeah.
leaves McDougal, Dickman, and Retzman to, if that's 3 in favor of
Yeah,
as
we carry.
proposed, but you could make a motion and see if it carries.
I don't know if I've seen Chair Seymour actually make the motions himself. It
Okay.
seems like he delegates that, so I don't know, if someone wants to make a motion for that or another
So
proposal.
is it possible to make a motion to carry it forward with strong objection to not considering the hosted rentals? I guess I'm not really sure the right word for that, but but there was the approve with, sorry, I've lost our options now.
Yeah, the motion would need to include some specific language
Oh,
that you'd want to include. But with that said, if a motion carries, we can, as staff can carry forward to the council, those points of
Thank you.
discussion
Yeah.
and interest otherwise.
Thank you. Yeah.
I'm glad you brought that up and brought it forward even starker.
Yeah, okay, thank you. Then I'll go ahead and make a motion to approve the, let's see, I've not made a motion specifically before.
It's you can give her the script.
Specific
Oh.
language.
Last page of the script gives some.
Oh, here we go. Part that I had not looked at.
Great, thank you. Okay, let's see then. I move to recommend to City Council approval of City File TA 24-01 as drafted by staff.
02. Yeah.
Oh.
Yeah, TA 2402.
Oh,
That's
it says.
That's my mistake.
Oh, okay.
Okay. Well,
We'll take that back and I'll move to recommend to City Council approval of City File TA 24-02 as drafted by staff.
I'll second that.
okay. Maybe a hand raise would be appropriate. All in favor?
I see Rick Retzman's hand up.
And opposed? The motion carries.
Can you speak into the record what the vote was?
Looks like the vote was 4-1 in favor of accepting the changes as proposed. Or, yeah, code text amendments for city file number TA 24-02. The vote is 4-1 to accept as proposed.
And Commissioner McDougall, you wanted to pass on some recommended language for the council to consider about some kind of hosted arrangement. And I just wanted to clarify, is that something that, you know, where you, similar to what's been discussed tonight about renting a room in your house, something of that arrangement would not be subject to a concentration limit? Is that what you are talking about?
That's what I would, yes.
Actually, I agree with that. I think that would be, and I guess you'd have to define owner occupied. Maybe it would get more in the weeds than we're.
It would probably take us coming back again with some language. You know, as Matt mentioned, I think that notion was forwarded to council at one time, but if you want to reiterate that,
sure,
please do, and we'll pass that on. And if they feel strongly about it, then they can either remand this back to you guys for further consideration or direct us to do it at a future date.
I'm not asking you to speak for them, but did they have any discussion on owner occupied?
I don't recall. Matt may. I just think it kind of maybe got lost in the shuffle with all the other issues they were discussing.
Definitely an interesting concept, but
Yeah.
completely different.
I don't never heard them being against the concept.
No, I would, yeah, I
But
think it would.
I don't want to.
I would like to hear it elevated again and, yeah, I just see it a lot differently.
I second that.
Yeah, I think it addresses the neighborliness, the vibe, for lack of a better way to put it, that you're looking for in a neighborhood, is that when you have an owner occupied place and it's like they have a guest. And even if they want that guest to pay, they're still there. It's not taking away a housing unit from some family that's trying to find a house.
I believe in the survey we read through, I think that's where the information came from. There were multiple people who may have an STR in their home that was helping them to afford to live here. So, that means a lot to me.
Well,
I know we can't solve the world right now, but, I do.
Well, in that respect, I want to commend you and thank you for your discussion tonight, and just clearly a divisive topic with a variety of opinions and interest in different policy directions, including the public comments tonight and that were submitted in the record. So I appreciate all the involvement to date. And just acknowledging that this is a recommendation to the city council that will carry forward to a subsequent public hearing before the city council. So any of those members of the public that are interested in continuing to be engaged, stay engaged, encourage that. And just want to acknowledge the city council recognize that this is kind of an ongoing discussion and an iterative process. So the discussion from the Planning Commission, the additional comments that we've received, will and can influence the process moving forward. So, you know, as Scott pointed out, if you know, we may be back with some refinement of these amendments, but certainly this was a great step in the process to bring something formal forward, receive some public testimony, and take some steps in a direction to kind of get to council for an ordinance. So, thank you for that.
It was a great discussion tonight too.
Yeah, this is one of those where I feel like the public comment, I learned more from public comment and public emails than I have on any other matter that we've had before us, for me personally, anyway. So, I guess we already kind of did staff and commissioner comments, but are there any other staff and commissioner comments before we adjourn?
I've got one. If you have a chance, you could probably look it up. It's 1,000 Friends of Oregon. They put on a land use initiative class that lasts like 7 to 8 months. It goes, it have meetings. There's meetings in Bend, there was one in Sisters, there was one in Redmond, we went to Prineville, a couple of them were online. And they just go through the whole land use planning laws that were passed 50 years ago and explain every aspect of why we're doing what we're doing. And, you know, it's been a real success in the state of Oregon because when they passed it 50 years ago, we were eating up huge amounts of farmland into development, and it really slowed it down. So the process that we're going through grinds slow, you know, but it stops us from just exploding with urban sprawl unless you're a Portland or a Bend. And that, you know, they've all struggled with it, but at least you get to understand about all the things that go into consideration of why we grow.
Yeah, just take a trip to Texas and find out why we have land use laws.
All right.
Commissioner, Vice Chair.
Sure.
Bickman, I just wanted to just let you guys know, you probably already know this, but no meeting on July 4th unless you want to come in for just, yeah. So the next meeting would be July 18th. And just let you know that the first steering committee meeting, of which Commissioner Blumenkron and Commissioner Retzman are a part of for the UGB steering committee, will take place next Thursday. So
Are those public meetings?
they are public meetings. Yeah. Yeah. We don't know how many people are going to come and what the capacity of the room might be, but I just want to let people know that they're able to participate via Zoom as well.
How does it here?
It is, yeah. And we'll talk about the land needs report, which is that first step in the process that kind of establishes and provides some analysis of how much acreage we need and of what type of land use. So kind of sets the stage for the rest of the discussion. All that information should be available on the project website, which is on the city website by the end of the afternoon tomorrow.
Great.
Thank you very much, everyone.
All right, we are
Have a good night.
adjourned.